Well, good morning. I'm Aaron Hall. We are going live. I'm an attorney for business owners and entrepreneurial companies, and we do these live sessions so that business owners throughout the United States and world can ask questions and learn more. This is an educational show. It's not about giving legal advice. In fact, I can't. I can't take time to understand your particular circumstances and the details and assess that situation and give you advice based on the laws in your jurisdiction. That's for a lawyer to do. What we can do today and what we will do is talk about business law to empower you with education so you know what to talk about with your attorneys, the kinds of questions to ask, and you know how to avoid problems before they happen. So, this is an educational show, and I want to make that really clear as we get started because that sets the expectations correctly and also it's legally required. I'm not practicing law here, but I do want to help you as a business owner avoid the legal messes and problems that so many business owners encounter, which can destroy their company, especially if they haven't had significant profits yet and they can't cover all the legal expenses. All right. Uh, let's talk about some of the common legal problems that people face. In fact, years ago, when I started working with business owners for the very first time, I started seeing mistakes. And I thought to myself, you know what? I'll just keep a little list of those mistakes I see so that I can be on the lookout for them in the future with future business owners. As that list grew, it was great because it allowed me to look for ways to help business owners avoid these same problems. And I started seeing them pretty regularly. I put together the top 7 of those on a list that you can download for free. Just go to aaronhall.com/free or look in the description below. And not only will you get the free list explaining what these problems are so you can avoid them, you'll also then get videos where I'm explaining from an educational standpoint how you can avoid these problems and how to better understand them and look for them in your company. So, all of that is available for you today for attending this live session, aaronhall.com/free. All right, I'm about to take your questions. I would ask, though, that you keep in mind whatever you ask here stays on YouTube. This is public. So don't share anything that's confidential. And keep in mind that everything you present here on the internet stays here on the internet and it will continue to be available for people to watch. All right, I'm going to start first with your questions. And if there are any questions here in the comments, you get top priority. And then we have a number of questions that were submitted in advance or identified in advance. They came in by email or other channels, and I'll address those as well. But if you have questions, put them in the comments section below. I look forward to getting to those. I don't see one yet, and that's okay. It takes a little time to get comfortable with the show, but feel free to add one. And in the meantime, I will answer a question that came in prior to the show. Do I read the terms, or it says, Aaron, do you read the terms of service of every website you use? Okay, so this is the topic of what's called shrink wrap contracts. So this is where, even before the internet, did you ever have this where you open up a box and inside are some terms of service and a warranty and you're like, well, hey, I already bought this. How could I be bound to this contract? Well, there's actually what's called shrink wrap law. And that simply says after you've bought something, if you open up the shrink wrap and see the product inside, and then there are some contractual rights that you have, You have a reasonable period of time, sometimes it's limited by the language in the contract, to return the product if you disagree with it. Why do I share that? Because by analogy, websites are the same thing. If you go to a website and there's some sort of terms of use and you have to check the box, or maybe you download an app and you have to approve the terms and conditions, usually you have a reasonable period of time. And by the way, what's reasonable? Prompt. So it might be a day, it might be a few days, but it's not a month, it's not a year. You have a reasonable period of time to return that product or delete the app or go away from the website. So, do I, as a lawyer, read those? Absolutely not. I mean, let's face it, it's pages, if not hundreds of pages on some of these. And there's no way that we can possibly spend all of our time doing that. So, realistically, it's not possible to read it. But every once in a while, I will, especially when the terms are really important. So, for example, if something costs a lot of money, I might take a look at the terms and conditions then. Or if my health and life and safety might be at risk. I went whitewater rafting in northern Wisconsin a few years ago. There's a resort there that offers incredible whitewater rafting, comparable to what you could find in like the Colorado River, but it's right here in Wisconsin. And before I signed the waiver on that, I read through it just to make sure there wasn't anything um, that I wouldn't feel comfortable with. You might say, well, what are you looking for? What wouldn't you feel comfortable with? Well, for example, if they're negligent, I don't want to be responsible for that. I'm willing to be responsible for myself and my own negligence. But if they're negligent, especially if they're grossly negligent, I think they should be responsible for that, not me. So that kind of thing. So, as a lawyer, do I read the terms of service of every website I use? No. It's pretty rare when I do. And when I do, it's when there's a lot of money or a lot of risk involved. Okay, let's see what the next question is for today. Oh, here's a quick and easy one. Could AI replace lawyers? What do you think? Uh, I suppose the question is, could AI replace any of these professions out there? It's amazing what's happening with ChatGPT. I've been using that a lot. But could AI replace lawyers? I think eventually. But here's my experience so far with ChatGPT. I tried to do a little legal research and I said, are there any cases that stand for a particular argument that I was trying to make in a court? And ChatGPT said, yes, there were three. I was like, oh, this is great. And it listed them. And then I said, give me the summary of those cases. And it did. I thought, wow, this is amazing. ChatGPT is a game changer for lawyers doing legal research. I then went and looked up those cases and read those cases. They didn't say anything about the issue I was dealing with. And ChatGPT's summary was totally incorrect. It was like ChatGPT was describing some other case. Unfortunately, I don't think that case that I was looking for even existed. So I don't know where ChatGPT got the information. Some people call these hallucinations. Uh, I think that's probably reading a little bit too much human into the scenario. In fact, I think what it is ChatGPT. It's statistical and it's prediction, and so it was coming up with information that may have made sense and passed the grammar and spell check, but it simply was not matching what existed in the law. So at this time, AI tools are not able to replace lawyers or even entry level lawyers. But I am trying out some tools right now that have just come out, not ChatGPT, but they utilize ChatGPT. These tools have all the federal and state cases in there. They have all the statutes. And so it has a lot of resources that ChatGPT doesn't have access to because not all of these cases are on the internet, and ChatGPT just uses the internet. So I do think ChatGPT can be great for certain purposes, and even these tools can be great for certain purposes. I'll give you an example of how I used ChatGPT recently. Was contacted by a restaurant owner who was looking at selling the business. And I said, you know what? I know what kind of questions I would normally ask a restaurant owner who wants to sell the business, but let me see what ChatGPT would say. And so I wrote in there, you are a lawyer. So I told ChatGPT, you are a lawyer who represents business owners selling their businesses, because I want ChatGPT to step into my shoes. You are about to speak with a restaurant owner. What questions would you ask the restaurant owner in preparation for getting the restaurant ready to be sold? Question mark. And then I add another statement. What factors would you need to consider when determining if the restaurant is ready to be sold? What are some questions to ask to potentially increase the value of the restaurant? I asked ChatGPT all that. The result was fantastic. I'd say about 30% of the responses from ChatGPT were not on my list in advance of the meeting. And I'd say about 40% of the items that I felt were important weren't in ChatGPT. What's the takeaway here? It's a great tool to augment or complement what you are doing as a professional, but it isn't yet a replacement for that. Do I think ChatGPT will be able to replace lawyers? Yes. A lot of simple lawyer tasks will be replaced. For example, I had a contract recently, and the contract, that template that I wanted to modify, had parties who were companies. So their pronouns were its, their, and it was a female selling to a male in my new scenario. So I had to change all the pronouns. I just explained to ChatGPT, I'm going to give you a contract. And by the way, I sanitized it of client information first before I put it in there, because whatever you put in ChatGPT can be used to educate it. So you want to make sure you're being very careful there. But I put in a sanitized contract, and I asked it to change all the pronouns and explained how, and it rewrote everything. So instead of hiring somebody like a young associate or a paralegal to go through and replace that, it was done in just a matter of seconds. So that's a great example of where AI can save time for attorneys, save money for clients, and allow attorneys to focus on what's more interesting and not the kind of minutia of practicing law. Other examples are you put 100,000 documents into ChatGPT and you say, identify the documents that support this argument or find this thing. It doesn't mean you can give up your job as an attorney, but this AI is an incredible way to augment or support what you're already doing with a powerful tool. In the old days, that when somebody was doing farming by hand, they might use a hoe or a shovel. And then came along the plow that could be pulled by an ox to break up the ground. If farmers said, hey, I'm not going to use this new efficient tool, I'm going to do it the old way, they were not competitive. Now, by the way, did the hand-drawn plow mean that everybody could now just do their own farming? Well, they could, but it doesn't mean they wanted to. Likewise, when we converted from the plow to the tractor, did everybody say, oh, now I can just buy a tractor and I'll do my own food? No. So I don't think people will say, now that I have AI, I don't need a lawyer. I think they'll just want to hire a lawyer who's using AI, using the powerful tools that are available, and being the most efficient and effective in what they're doing. So I believe AI is a new tool, and it's incumbent on lawyers to utilize AI to effectively serve their clients in the future. I don't believe it's AI will wipe out the profession of law. Okay, let's move on to the next question. What are the top 5 write-offs for LLCs that most business owners forget? And I think this is especially for new business owners. In fact, this question could be asked another way. What write-offs are available for LLCs that new business owners may not know about? Well, here are the top 5 that I've identified. First, tools. You can buy any tools you need to get your business done. So that's going to be smartphone devices, computer hardware, accessories, anything that adds efficiency to what you're doing. Um, in my business, for example, I have invested in high quality, high speed ergonomic keyboards, um, mice, quality microphones, lighting, a very large monitor so that I can have 3, 4, 5, 6 documents up on my desk. My monitor is almost as big as my desk. These are investments that you can deduct 100% when you are a small business owner, as long as they are tools that help your business. Likewise, software. That's number 2. Any sort of software that makes your system go quicker. Um, there, I use a lot of software unique to my practice that adds efficiency, and this includes iPhone apps and whatever software you can use to simplify your keystrokes, shorten what you're doing. For example, I use Text Expander. Text Expander is a tool that allows me to type in just a few letters and it will fill out a full line of text, whatever I ask it to be. For example, if I need to type in the full date, I can just type in 3 characters and the new date will come up. Third, so these are write offs for LLCs that most new business owners may not know about or would forget. Education. This one's huge. Any sort of training, books, online courses, any sort of paid program that you go to improve your effectiveness, your skills, any coaches or consultants. It's just an incredible opportunity to invest in yourself. And so a lot of times you were already as an employee somewhere else making these investments in yourself, and now they're tax deductible when you own a business. Fourth, brand building. What is this? This is the cost associated with building your personal brand. It could be stuff as simple as upgrading your account from a free account to a paid account for something, like YouTube Premium, Twitter Blue, which allows you to add longer videos. Maybe it's pay-per-click remarketing. What is that? That's when people who express interest in your business go to your website and then they leave. And for the next 30 days, you can have your ads continue to show up for those people who have already expressed interest in your business at your website. And those ads show up on other sites like Google. So that's called remarketing or retargeting. It's a specific way to continue to stay on the mind of somebody who's already shown an interest in you. And it's extremely inexpensive because if you have 100 people, you're paying for 100 ads, and usually it's a fraction of a penny per ad unless they click on it, and then a click may be 10 cents or 25 cents. So that brand building is a very inexpensive way to grow your company and your brand, your personal brand, even if you later benefit from that personal brand by getting a great job at a great company. So that's an expense you had to pay on your own before you owned a company. And now that you own a company, it can be a tax-deductible business expense. And then finally, fifth, travel, meals, and entertainment. Now, this is an area that the IRS keeps a little bit of an eye on. And there's some rules on how to handle this. For example, if you go on a trip and you spend the whole time with your family at Disney World, that's not going to be deductible as a business expense. But if you go on a trip and a majority of the time is spent on business purposes, and then you had some leisure days as well, that's tax deductible for you. And if your family members are employees and they're participating in the business aspects of it, it's tax deductible for them as well. All of these ideas you'll want to run by a CPA. There is one guiding rule that you should keep in mind with it. The IRS says the expense needs to be ordinary and necessary. So in other words, you can't, for example, be running a dog walking business and taking travel to other continents throughout the year. That makes no sense. If it's a local dog walking business, it wouldn't make sense that you're doing international travel. But if you are a public speaker speaking on issues of international relevance and you are traveling for that and getting per diems and payments for your speeches, of course it would make sense. And of course, you can do some retreats from time to time with your staff. And if your family members are your staff, they're welcome to go on those retreats. One more bonus I'll throw out here. If you set up an S Corp, or if you have an LLC taxed as an S Corp, you most likely can deduct your health insurance premiums. That can be fairly significant. So these are all items to discuss with a CPA. Sometimes people say, is it worth having a CPA? I find it's worth it for three reasons. First, they usually save you more money than they cost. Second, you get incredible peace of mind knowing that when you use a CPA, you can rely on them and you're not accidentally violating the law. And the third reason is a reason most people are not aware of. When you rely on the advice of a licensed professional, so a CPA or an attorney, in a tax question, if that reliance later turns out to be wrong and you actually owed money on the taxes, it is an important defense to any sort of tax fraud crime that you relied on the advice of a licensed professional. So, and I don't mean bookkeepers. A lot of people out there are not licensed CPAs or licensed attorneys. It's important that this be a licensed individual. And I would recommend keeping a record of the question that you asked so that if there ever is an audit and the advice was wrong, at least you have that defense that you consulted with a tax professional and relied on the advice of a tax professional. That can save you from going to prison. And it really matters when it's something really big. Okay, let's take a quick look at the questions that have been submitted here. All right, next question. Why should you not form an LLC? Well, everybody loves LLCs. They're great. They're one of the most popular business types. But there is one very important reason why you should consider not forming an LLC. And then there are some less important reasons that might matter to you. The most important reason is because it is an S corporation who gets a taxed benefit. The default rules for an LLC are you do not get the payroll tax benefit that an S corp gets. Let me explain how that works. Let's say in an LLC that you're the sole owner and the LLC generates $200,000 in income, but had $100,000 in expense. So that means you only have $100,000 in profit. But still, that's good money. In an LLC, the default rule with the IRS is that you are not taxed at the LLC level, you're taxed at the personal level. It's called a pass-through entity. So you're going to pay two types of tax on that $100,000. Income tax, like everybody pays when they have income, and payroll tax. What is payroll tax? It's roughly 15%, and it's the payroll withholdings that apply whenever you are working for somebody. Typically, the employee has payroll withholdings and pays the payroll tax of about 7.5%. And then the employer pays 7.5%. That adds up to roughly 15%. But think about it. In this scenario, you're both the employer and the employee. So you have to pay the whole 15%. So now you are paying on that $100,000 15% payroll tax, plus whatever the federal income tax bracket is that you're in, plus the state income tax bracket that you're in. So that's a pretty high amount of money. That's an LLC. But for an S corporation, there's a significant discount in many circumstances. So using the same scenario of an S corporation this time earning $100,000, let's say the job that you are doing for the S corporation is only worth $50,000. In other words, if the S corp were to hire an employee to do the job that you're doing, the S corp would pay a salary of $50,000 to that employee. Well, that's how for this scenario, we'll treat you that way. The S corp is going to pay you wages of $50,000. That leaves the other half of the profits, $50,000, available to be paid out as a profit distribution. Wages are subject to the 15% tax. Profit distributions in an S corp are not. So you are saving 15% of $50,000 in this scenario. And that's every single year. So as you can see in this scenario, 15% of $15,000, that's thousands of dollars. That's a lot of money in your pocket every year. I'm not talking about an additional deduction or a credit or an exemption. That's actually cash in your pocket. You are avoiding having to pay that payroll tax for the $50,000 that exceeds your wages. So an S corporation has an incredible benefit. Now, if the company's only making $20,000, that benefit's not going to kick in because you have to pay your wage in an S corp or an LLC. And if you're only making $20,000, it's not going to cover your whole wage. So if you're thinking about this, you might say, well, hey, why don't I just pay myself $1 in a wage? That way I'll pay 15% tax on $1, and the $999,000 or $99,000, $999, that all comes in free of the payroll tax. Well, the IRS thought of that. And the rule is you have to pay yourself a fair market wage. So what you want to do is take a look on Indeed or Craigslist and see what's a fair wage. And then I would even recommend saving the evidence of the wage or the job postings for the kind of job that you're doing. I'd also recommend running it by a CPA or a tax attorney. That way you have the protection of a licensed professional reviewing whether you made a reasonable wage when setting your wage in an S corp. You might wonder, if you have an LLC, can you still get the payroll tax benefits in an S corp? Yes, you can. An LLC can elect to be taxed as an S corp. But you can only do that if your LLC otherwise doesn't violate S corp rules and you need to then treat your LLC essentially as an S corp. So you can't have the benefits of both, if you will. You can't have an LLC that has all sorts of things that would not be permitted in an S corp and then get the tax benefit of the S corp. The IRS doesn't permit that. All right, let's take a look at the next question. Why won't a lawyer take my great case on contingency? I saw a great example of this recently. A business owner had been mistreated by another business owner. We'll call him the good business owner. The good business owner was cut out of the business, lost access to all the financials, and the bad business owner started keeping all of the money. And the good business owner said, I'd like to hire an attorney, but I don't have the money to pay out of pocket. Can I pay a contingency fee? What's that? A contingency fee is when an attorney only gets paid if they recover money. So contingency means triggered. So if money results from the case, then, or under that contingency, the lawyer gets paid. Well, if it's a great case, why not? Here's why lawyers are really skeptical of cases on contingency. Because often clients don't tell the lawyer the full scenario. The lawyers don't know what the other side is going to say. I have had some cases that looked incredible when they first came in. And when I first started practicing, I was more willing to do contingency cases. And then as you get into the case, you find out awful stuff about your likelihood of winning. In fact, I once had a case, you may not even believe this. I had a case where I found out my client got drunk and ran her car into the home of the opposing party. That really hurt my case. I don't care how strong the facts were in the case. That doesn't seem like a very nice person. And when a judge has to decide who should win and who should lose, whether a person is a good person or a bad person often comes into play. So contingency cases are highly risky for lawyers because at the time you agree to take the case, you have no idea what the other side's arguments are, what their defenses are, and what information your client might not be telling you. And in a business dispute, it is extremely rare for one side to be an angel and the other side to be a devil. Usually they both made some mistakes and they both said some things they regret and did some things they regret. And so I know it's highly likely that if we start a lawsuit against the bad business owner, we're going to get counterclaims back. And then what may look like $1 million case might end up where my client owes money. Well, that means as a lawyer, I'm not going to get paid. So, and even if we require, or even if the good client ends up going to trial and wins $100,000, and let's say it was a 40% contingency, and the attorney then gets $40,000, that is a terrible deal for the lawyer because a lawyer will spend maybe a year or two and an extraordinary amount of time and money and tools to win a case like that. A case like that usually is going to cost $150,000 to $250,000 in legal fees. So the lawyer is losing money if the lawyer only gets $40,000. And I realize that sounds like a lot of money, but keep in mind, lawyers get that money and then turn around and pay staff and overhead and insurance and tools and all the things necessary to run a business. It's kind of like saying, oh, bakers must be rich. They get all the money from the donuts every day. Well, no, the baker turns around and pays for the people who make the bakery goods, pays for the ingredients, pays for electricity, etc. So contingency fees for lawyers are very appropriate for personal injury cases, accidents where it's clearly an insurance company on the line. The question is just how much can you get? But in these cases where they're hairy, they're going to be arguments going back and forth about, well, you did this, no, you did that. Contingency fees rarely work out. So that is why uh, a lawyer is going to be very unlikely to take a business dispute on a contingency basis. Next question. What is a hybrid contingency fee? Well, that's very appropriate right now. A hybrid contingency fee is where the lawyer gets a percentage of whatever's won, but also gets paid by the hour. So, for example, the lawyer might get $200 per hour plus 20% of whatever's won. That way, the lawyer at least knows expenses will be covered, but has arguably an incentive and a piece, some skin in the game to win. Those rarely can work. And I say rarely because normally lawyers aren't going to want any case on a contingency. It's not that the lawyer doesn't believe in the case or isn't going to work just as hard. What it is, though, is lawyers don't know the scenario that they're litigating until they get deep into it with their client and they hear the arguments of the other side. And so most lawyers are just simply not willing to take the risk of a business dispute on a contingency fee unless they just don't have enough other work and they need to take something like that. Next question. If I can't register my LLC in every state where I do business, is there anything else I can do to protect myself from unknown lawsuits? Another way to put this is if I don't want to register my LLC in every state where it does business, is there anything else I can do to protect myself from unknown lawsuits? Okay, what is this question talking about? If you have an LLC in Minnesota and you do business in New York and California as well, like for example, you might sell to customers there, you are required under New York law and California law to register your LLC in New York as a foreign LLC. And you're required to register your Minnesota LLC in California as a foreign LLC. Why? Because if you ever get sued there, parties have a right to serve that lawsuit on the state government, like the Secretary of State. Every state designates who can receive that lawsuit. And if you are not aware of that lawsuit because you're not registered there, you'll never know that you need to respond. So here's a real example. Many years ago, a company contacted me and they said, we just found out that there was a lawsuit against us in Minnesota and we lost. And it was a bogus lawsuit. It claimed we engaged in racial discrimination, which we didn't, and we've got all sorts of defenses. But because we didn't even know about the lawsuit, we of course lost, and the other side won by default. What can we do? And I said, well, how did you find out about this? Because ultimately you did find out. They said, we found out because they froze our bank account here in this other state. So I said, oh, wow. And it was a lot of money. And there is a process to try to undo a judgment when it's already been issued and you didn't know about it. But it's very difficult to win. The odds are stacked against you. So if you want to avoid that sort of scenario, you need to register in the states where you're doing business. So for example, if this company had registered in Minnesota, then when the lawsuit was commenced against them and the Secretary of State in Minnesota was served the lawsuit documents, the Secretary of State would have known who to send those documents to, and the company could have hired an attorney to defend them. So the risk is if you don't register in other states where you're doing business, you may never know about the lawsuit there. But what was the question? The question is, okay, if I don't register, is there anything else I can do to protect myself from unknown lawsuits? Probably the best thing you can do is make it really clear to whoever might be contacting you that who they should contact if they have any issues or disputes. So at least you are aware of the issues and it's not like an unknown lawsuit will be brought against you. One other thing you could consider doing, and that is you could consider having an arbitration clause or a venue clause in your contract with people. Now, not every lawsuit's based on contracts and breach of them, but to the extent you're selling to customers, you can have what's called a shrink wrap contract in there, which says, for example, if they want to sue you, they must sue you in your state. And you could even say it must be in one of these arbitration forums, so JAMS or American uh, Arbitration Association. So, in other words, rather than being able to commence a lawsuit in New York District Court or California District Court, under the rules of the contract, they have to commence the lawsuit in your home state or in an arbitration venue. Okay, let's take a look at the next question we have. When you register your LLC and can't use your home address, what are your options? What's the difference between a virtual office, physical address, and registered agent? Okay, virtual office means a lot of things. A virtual office might be a mailbox that you have someplace to accept mail for you. It might be a co working space, or it might be an office that you go to from time to time. It could be a desk that you rent at somebody else's space. It can mean a lot of different things. And so I don't find the term virtual office very helpful when dealing with this particular issue. So the question then is about physical address and registered agent. When you register an LLC, you need to have a physical address so that if you get sued, somebody can hand that document to a person at your location. A physical address could be your home. So if somebody sues your home, you'll get that lawsuit document because somebody will walk up to your front door and hand it to you. But you might not want it to be your home. Many people are fine with that because they don't plan to get sued. But you might want some more privacy. And so in that case, you can pay a company for a registered agent service. A registered agent service is a physical address for your company where somebody will be present to receive documents on behalf of your company. Typically, you pay a fee for this. From what I've seen, it's between $100 and $150 a year. There are a lot of registered agent services throughout the United States, and often a national service will contract with an accounting firm or a law firm to actually be the physical office. In fact, my law firm was previously a registered agent for one of the big companies that registers LLCs and corporations online. And that means every LLC that was registered through that company was set up with our address. And if they paid for a registered agent service, we would accept the lawsuit documents for them and then scan those in and forward them on to the company so that they could get to the LLC owner. So a registered agent service is a physical address that fulfills the statutory requirement for an LLC to have a physical address somewhere. and it allows you to keep private your home, for example, or your office, and just have a paid physical address for a very small amount of money just to handle if you get sued. By the way, a little practice tip here. You probably don't want to use that same address for all your other mail because you will typically pay a fee for every document that they need to scan in. Or you might have a max of like 5 documents. And often when you set up an LLC, you get a lot of junk mail. So, what some of my clients do is they set up a registered agent service for the address of their LLC. And then they might set up a PO box or some sort of virtual service that can handle all the incoming mail, scan it in, and email it to them. That keeps their costs low. Next question. What is the court of equity? Is equity part of the legal system? Prior to the founding of the United States, the court systems were the court of law and the court of equity. And going way, way back, without getting into too many details, essentially the court of equity was run by the church and the court of law was run by the government. And if somebody couldn't get justice in the court of law, they would have the opportunity to go to the court of equity to see if they can get justice there. And because the religious authorities had so much weight and authority in society at that time, the court of equity was respected and followed by many, if not most, people in society. And unfortunately, people often couldn't get justice in the court of law. Maybe they lost on a technicality, but the court of equity looked at what is inherent justice in the situation, what's the right way to handle this situation, rather than what is technically the law and did somebody follow all the technicalities. In the United States legal system, we have merged the court of law with the court of equity. I'll tell you a little story. There was once a judge appointed by Ronald Reagan who handled a huge case in the United States. And I don't want to identify this judge because I don't have his permission. So I'm going to keep the details brief. But a very large case, and the judge issued a ruling that was extraordinary in the minds of all the experts who were following this case. In fact, I spoke with a number of the experts, and they thought that the judge's ruling was absolutely not in accordance with the law. Well, I asked the judge about this one time. I had an opportunity to talk with him. And he quite simply said, I was sitting in a court of equity. What he essentially meant was it didn't matter what the law said if the outcome would have been unjust. Operating within his authority in the court of equity, he could bring about justice to the situation regardless of whether the statutes would accomplish that. Now, that was a fairly bold decision. Judges can get in trouble and occasionally even overturned when they deviate too much from the law. But this was an Article 3 judge, which means the judge was appointed by the president, and the judge determined he was well within his authority to make that decision. And by the way, it turns out he was. The case was appealed, and that particular aspect was not overturned. What's the point here? The point is that it's not enough to win on a technicality in court. You also want to appeal to the judge's sense of justice or the jury's sense of justice if you have a jury. A great litigator who's no longer with us once told me, when you go to argue your case in court, remember that judges are made up of both hearts and minds and argue to both of them. In other words, go ahead and argue the logic and the reasoning to the mind, but also you want their heart to want to support you as well. So it's important that justice be on your side and you explain how that is. Being attentive to both of those pieces makes you a great lawyer. So, what is the court of equity? It's essentially the idea that even when the laws don't have a just outcome, courts have the authority to bring about justice in extraordinary circumstances because of their authority in the court of equity. What is the difference between civil and criminal law? This is a great question. Quite simply, criminal law is charges where the government says you committed a crime and there is a consequence that you will pay to the government. It could be a fine or imprisonment, for example. But with criminal law, it's always the government bringing charges against a person. Whereas in civil law, it's usually people suing each other. And you can't go to prison for a civil violation. You'll just owe money to whoever's rights you violated. Now, there are times when government agencies are involved in civil law, but they're involved just like any other party. They have civil rights, just like individuals have civil rights. So the main difference between criminal law and civil law is, were you violating a criminal code which could result in a criminal penalty like prison or a fine that's paid to the government? Or in the case of civil law, did you violate someone else's rights and they're suing for the damage to them? Okay, we are coming up at the top of the hour. I'm looking to see if there are any final questions here. I do not see any more questions that need to be answered today. Um, let's let's handle one more question here, which is, who owns the copyright to artificial intelligence images you create? So, when you create AI images, who owns the copyright? This was an issue recently analyzed by the United States Copyright Office. And here's what they said. If there was very little guidance provided by you in prompting the AI tool to create an image, you don't own that image because you didn't bring enough value to the table. Tools can't own an image because only people can own copyrights to images. So nobody owns the copyright to it. So what are you to do then if you want to use AI tools to create an image and you want to own a copyright to it? You should document the creativity and guidance you brought to the process of creating that image. The more creativity and guidance you provided, the more likely you are to be able to own the copyright for that image. If you typed in numbers into a calculator and then hit a button and the calculator did the calculation, would you own a copyright to the output? No, because you didn't. All you really did is type in something and it calculated it. That's how the US Copyright Office looks at AI tools. If you just say, show me a picture of a girl with sunshine in Wisconsin, well, there's no real creativity involved there. So you're not going to own the result that is produced by a machine. However, if you provide it very detailed descriptions, and perhaps you even look at the results and continue to refine it, that is more like the work of a painter or a graphic designer. And that is a case where you will own the copyright. So the tip and takeaway to make sure you own the rights to artificial intelligence images is this: keep track of the creativity and prompts and direction that you give, so that if there's ever a question later about whether you had sufficient artistry, you have a record of it. All right, that wraps it up for today. I'm grateful for you being on this live video. This live, at least for right now, is not going to be available for others in its full form. We'll probably use parts of this and roll it out on various social media platforms. But if you are interested in being notified about future live sessions, usually we send out a notice a couple days in advance. You can get that notice in two ways. You can subscribe to this YouTube channel and turn on notifications, or you can get our emails. To do that, go to aaronhall.com/free, enter your email address, and you'll know about these free live YouTube sessions, and you'll also get access to exclusive videos that aren't available to the public. It was a pleasure having you here today. I look forward to seeing you next time.